Everyone will please rise. Circuit Court of the 19th District Circuit in Florence County, Florida is now open. The Honorable Dalton Perry Jr., Chief Justice presiding.
You may be seated. Okay, Madam Clerk, you may call the case.
2008-156-0.
Okay, let the record reflect that the Assistant State Attorney is present along with Mr. Baez, Mr. Mason, and Ms. Anthony. Okay, Mr. Ashton, we're hearing your motion, sir.
Thank you. First of all, thank you for accommodating us at this late hour. I know you've been busy this week, and we do appreciate it.
Well, just in a town for the last 2 days.
Yes, sir.
It seems to go on and on.
Yes, sir, they do that. What I'm requesting in my motion for clarification or to compel compliance refers to the court's order, first oral in the hearing, the last hearing we had, and then reduced to writing. In that order, the court stated that the defense shall provide to the state by 4 o'clock on December 3rd, and I'll read from the order, a list of defendants' experts that shall include the subject matter as to what the experts will testify to and the area of expertise for each expert. We received the initial partial compliance with that on Wednesday, December 1st. I've attached the emails to my motion for the court's examination.
Was it in the email or was it in the form of a file pleading?
No, sir. Everything we've received has been in the form of an email. No file pleadings. The email, as you can see, listed some general area of expertise, as to some slightly vaguer than that. In response to that, there were emails back and forth in which we requested whether the defense was going to comply with the order. In the context of my response, I left open the possibility that this was a partial compliance and that further compliance would come later in the week. Through emails back and forth with Mr. Baez that I've attached, it became clear that Mr. Baez was not intending to give us any further information other than the last email, which I've also attached, which was received on Wednesday the 1st at 11:42 a.m., in which there are some commentaries about various witnesses. I want to direct the court's attention to two specific areas that I think highlight our difficulty. One thing I will tell the court, for the record, is we are trying to get these depositions done as quickly as we can. We have we have about 7 weeks to complete all of these depositions. Our thought is that we need to get all this done by the end of January if we're going to have hearings in February to comply with the court's order. We have our first deposition, which is set in, I think, Wednesday or Thursday of next week, of a Dr. Fairgrieve. Dr. Fairgrieve, and again, we've researched his background. He's a forensic anthropologist. We've looked at his writings. He's listed here, and it just simply says canine issue. As mentioned, he will testify at that hearing if we have one. One other thing that has exacerbated our difficulty is that the deadline for filing of motions on scientific issues requiring testimony was November 30th. We have received none. So our difficulty is compounded because we're trying to depose witnesses like Dr. Fairgrieve, who supposedly are going to testify relevant to a motion that hasn't been filed yet. So we're sort of doubly prejudiced in not really knowing what to ask Dr. Fairgrieve. I will also comment that we've done our due diligence to try and investigate his background to see what he's published on, what his area of expertise is, and it does not appear to involve cadaver dogs or canines. So obviously that's an issue. One other area that is of particular sort of example is Dr. Freeman, who is described as a forensic epidemiologist. Obviously, epidemiology is a study that, if you look up the definition, doesn't really appear to have much application to the facts of this case. generally, and I'm probably going to be corrected by bloggers, but generally it has to do with the study of how diseases spread through communities. As you can tell, there isn't an obvious connection here. Adding to that, apparently Dr. Freeman wants to charge us $575 an hour to depose him. So, we're going to spend $575 an hour fishing around trying to figure out what he has to do with anything. Some of the other doctors or other experts, we've been given some, well, the general tenor of the last communication on this issue was that Mr. Baez acknowledges that he's only telling us what we already know. He's giving us no additional information. This ultimately comes down to what the court intended by what it said. If the court feels that this information is what the court meant when it said subject matter that they're going to testify to, then fine, we'll soldier on and we'll do our best. Our belief is that the court intended something more than that, something perhaps closer to a brief summary of their testimony. And we haven't gotten that. And if the court felt that we were entitled to that and should have gotten it, then we would ask the court to compel a defense to comply, or if they need clarification on what the court intended, to clarify the order so that we can get this information, get these depositions going, and be ready on the court's schedule. Thank you.
Response from the defense.
Good afternoon, Your Honor. I, quite frankly, don't know why we're here. I had, upon submitting the subject matter of what each witness was going to testify to, I saw the response from Mr. Ashton that he was not content with my answers. So then I filled in a little bit more of the blanks. I gave a more descriptive version of what they may testify to on the specific issues that they were involved in. Mr. Ashton is intimately involved with every forensic aspect of this case and knows exactly what these witnesses will testify to. At the end of and you can see the final email between the two of us, I said the goal here is to work together. Please check below, and if you have any questions, let me know. Well, Mr. Ashton didn't let me know. Instead, he decided to take up our time here this afternoon and file this motion. A phone call would have done it, a response email or something to that effect. If he wants to know more about these witnesses, we're not here to hide anything. In fact, I think the court threw him a major bone by actually giving them the subject matter, requiring us to give them the subject matter of what they're going to testify to, which is far more than they ever gave us with our 350 plus witnesses that we've had to take well over 120 depositions of just to find out what some people were going to testify to. We've come across all kinds of surprises and been dumbfounded with numerous witnesses, including expert witnesses, as to what they're going to testify to. I think this is a huge waste of time. Could have been resolved by a simple phone call from Mr. Ashton or an email of sorts. We're here, short of a script of what they're going to testify to, be more than happy to tell Mr. Ashton whatever he needs to know. But I don't understand, as I said, why we're here based on this. And I think it's nothing but nonsense. All of these resources are being exhausted because Mr. Ashton can't pick up the phone and call me.
How many expert witnesses did the state of Florida list, Mr. Baez?
Approximately 20.
Okay. And out of the 20 expert witnesses that the state of Florida listed, how many reports of the experts finding out of the 20 experts were turned over to you?
Approximately 12. There's several that have not written reports. About half of them.
Okay. And how many experts have you listed?
13.
And how many reports did your experts author?
None.
Okay.
We have one that recently submitted an affidavit, which I'll be attaching to a motion. That's about as far as any of them have submitted.
Thank you, Mr. Baez.
Yes, sir.
Mr. Ashton, Do you concur with Mr. Baez's statement that not all of your experts listed authored reports?
No, sir, I do not. Every expert who is going to render an opinion upon the analysis of evidence has presented a report. I can't think there is one person who is an assistant to one of the forensic anthropologists who prepared a video superimposition who was listed as an expert because technically there's an expertise involved who didn't do a report. There are a few people at the FBI who were involved in the handling of evidence who technically are experts who were listed and did not prepare reports because they have no expert opinions. Every expert who is going to render an opinion in this case, to my knowledge, and counsel can correct me, has given a report, and sometimes very thorough ones.
Okay. On what date was the defendant indicted for murder in the first degree, Mr. Ashton?
Oh boy, I think it was October, I want to say the 12th of 2008. I could be wrong on the date, but it was October.
Okay. And Mr. Baez, on what date did you file your motion for discovery? So since October of 2008, discovery has been going in some ways back and forth through 2009 and this year 2010, correct? Okay. Gentlemen, there is a trial date which is quickly approaching, and since y'all can't seem to agree and y'all can't seem to understand what I meant the last time, this is what I'm going to do. It is hereby ordered by this court, where experts have not prepared reports or examinations of their reports on their examination of tests, both the state and the defense are required to provide the following, and you will receive this in writing. The expert's curriculum vitae, qualifications of the expert, the expert's field of expertise or medical specialty, a statement of the specific subjects upon which the expert would testify and offer opinions, the substance of the facts to which the expert is expected to testify, and last but not least, a summary of the expert's opinion and grounds for each opinion. With the exception of the person whose deposition that will be taken on Wednesday, all of this must be completed by 3 p.m. on December 23rd. The one where the deposition is to be taken on Wednesday of next week, that is to be done by noon of Tuesday of next week. It is to be filed by a pleading in court. You will be able to get a written order probably within the next 30 minutes. Anything else, folks?
One small matter, there is one expert who is scheduled for deposition on the 20th, I believe it is. So if the court...
Who is that expert?
Dr. Bach, Jane Bach. She's a botanist.
Then she will be moved to that Tuesday deadline.
Thank you.
That goes for both the state and the defense on people who have not authored reports. Anything else?
No, sir.
Mr. Baez? Okay, do you want me to email those to you, or do you want to hang around for them?
I would be happy to have the order emailed, Your Honor.
Okay, all right. Thank you very much.
Thank you, sir.
Mr.